Hello, everyone. This is Diva with the Diva Lawyer Social Club. I'm here today with a new video that is going to be really short. I know the video last week was really long, but I do hope that you all did watch that video and learn something from it about the difference between a corporation, a limited liability company, and a partnership. Today, I want to talk to you about 5 legal tips for life. And these are going to just be 5 tips that I want to give my viewers that can help them try to avoid bigger problems later on down the line. A lot of attorneys will advise people to try to take preventative measures to get a general understanding about the law in various aspects so that you can take preemptive steps to prevent problems where as opposed to waiting until a problem arises and then you need an attorney and things aren't set up right, and then that's going to end up costing you a lot more time and money and expense and possibly heartache because you didn't take the simple steps ahead of time to avoid disaster at a point in the future. So these tips are just very general tips that I encourage people to read more about and study more about and try to set up in their lives or to make practices of in their lives so they can try to avoid major problems at some point in the future. The first tip goes back to what I was talking about in the video from last week, the difference between a corporation, an LLC, and a partnership. And again, I just want to reiterate that it's a really good idea that each of us has some kind of business that we do engage in outside of our normal 9 to 5, or unless I do know a lot of people who are entrepreneurs and who run their own businesses full time, but then I know a lot of people who are scared or timid about just going out there and being an entrepreneur and just running a business full time. But I do still encourage people who even have a regular 9 to 5 job, a regular W-2 job, to do try to have a business on the side that you engage in and that you try to have another stream of income from. And if you do have that set up, or if you're planning to get that set up, to set up also a business entity such as a corporation or a limited liability company. And if you look at the video from last week, I discuss all the benefits and the pros and cons of having a business entity in place that can help you keep your business separate from your personal affairs, and how all those different entities can help you tax-wise and liability-wise. The second tip is to get it in writing. Now, if you are a business owner, you probably do have a lot of contracts and documents in writing that set out the terms and conditions of your services, or that explain the refund policy for a product you might be selling, or something to that effect. However, a lot of times when we're dealing with family or friends, we often just rely upon handshake deals and, I got you deals that often lead to a source of problems between casual relationships that we don't think to get something in writing to govern our agreements that we usually have with our family or friends. So it's always advisable that even in simple transactions, like if you're loaning someone money, say you want to loan your best friend $5,000, it's always good to just write a simple 2 or 3 sentence document that states, I'm going to loan Abby $5,000, and Abby agrees to pay me back by December 31st, 2021. That way, it's clear that you intended to loan the money to your friend and that she intended to pay you back, and that she did agree to pay you back by a certain date. That way, if a problem arises and she doesn't pay you back, you then have a clear-cut agreement there to take to court to get your money back. Whereas if you don't have that agreement, Abby could say, oh, that was a loan. I never agreed to pay that back. I thought you were giving him, not that was a gift. I never agreed to pay you that back. I thought you were giving it to me. And then it's going to be harder to establish what the situation was if there's not a document that spells it all out. And again, it's nothing. You don't have to have like a major contract that's 20 pages long to deal with just basic affairs. Um, but you shouldn't ever hesitate to just jot down some terms and conditions on a piece of paper and have the parties who are in agreement with that sign off on it, so that there's no discrepancies later on, or there are no issues later on about who had a duty to do what and whether somebody breached that duty. Um, the third tip, getting back to the contract situation, also, especially when dealing with with contracts that do involve business dealings or major money or major situations in your life, like buying a house, buying a car. Um, I would always suggest that you speak with an attorney, um, preferably an attorney who has some knowledge in that particular area of law, and just sit down with the attorney and have the attorney review the contract before you sign it. Especially with a real estate deal, I would definitely have a real estate attorney review any contracts you sign before getting involved in a real estate deal. Um, I've never used an attorney to review a car finance agreement, but it's never a bad idea because a lot of times people do get caught up with the high interest rates and things on the car notes and the car deals. So if you do have that ability to have an attorney run by that kind of contract and make sure it's clear, that's also a good idea. With lease agreements, and this is where I would really advise someone to seek an attorney to review a real estate lease agreement, because a lot of those agreements provide for prevailing party attorney fees, which, in my opinion, if you're going to have that kind of provision in an agreement, you want to make sure, excuse me, you want to make sure, if possible, that the, the, the prevailing party attorney fees are capped at a certain amount. So that way, if you're going to have to litigate a case against the landlord, or you're going to try to fight an unlawful detainer action, and then that litigation drags out, the attorney fees on both sides might be pretty exorbitant. And then if they're not capped, you might be looking at having to pay the other side's attorney fees that can be $20,000-$30,000. But then also it can work the other way as well. But that's just a provision that you might want to be cautious about, and you might want to have an attorney review before signing that kind of provision. Also, you want to pay attention to what's called an arbitration clause. A lot of contracts now have arbitration clauses where they require the parties to forego going to court and litigating the case, and they agree that they'll take it to a neutral arbitrator that will have a final and binding decision about what's what. And I never like those kind of provisions in a contract, but I do know a lot of people won't even negotiate that out, because a lot of companies want the arbitration clause in there because, of course, arbitration is a lot less expensive than litigation, but sometimes that can be disadvantageous. So it's always good to have an attorney review any contracts that are really important, and just have an attorney review that to look for any major issues, and then also to try to get certain affairs. I mean, if it's like a $50 loan to a friend, I don't think that's a big deal to have to put in writing. But if we're talking like thousands of dollars and things, you might really want to consider having a document that spells out the terms and conditions of the situation. Um, the third tip, and this is what I say continuously and repeatedly, because I just see so many people who are not aware of what is called the Miranda Rule. I refer to it as the STFU rule, the shut the flip up rule, because it's a really important rule that a lot of people really need to understand. And I very, very often see a lot of people getting caught up in criminal cases because they're just telling on themselves, and they're talking to the police even after the police have read them the Miranda rights and say anything you say can and will be used against you in a court of law. And people will hear them tell them that, and then the officer will say, do you want to talk to us? And they'll just go ahead and start spilling their whole beans. It's really, really important to try to practice and abide by the STFU rule as much as you possibly can. I know there are some situations where you have to make a determination about whether you're going to assert your right to remain silent and not answer questions of law enforcement. But sometimes, I mean, like with a traffic ticket, a traffic stop, your better bet might just be to engage them briefly to give them your license and registration, and then wait for whatever traffic citation they're going to issue you. And then if they start questioning you about, well, where you've gone, where you've been, where you're going, at that point you have to determine if you're going to ask the officer, look, am I under arrest or am I free to leave? If I'm going to be interrogated, I need to have an attorney present with me. And have I committed a violation? Are you going to write me a ticket for something? Or are you just questioning me? A lot of times they'll say, well, you're being detained and we have the right to da da da. But just understand that you have no obligation to answer questions of law enforcement. So, and it's highly advisable that you never do that without an attorney present, especially if you are sitting in handcuffs at a jail being told that you have a right to remain silent. At that point, that should be a cue that you need to start asking for an attorney, and then just close your mouth. This does not mean that if you don't talk to the police, I mean that if you do talk to the police that you won't be arrested, or that if you don't talk to the police you won't be arrested. You may still end up arrested. The purpose of not running off at your mouth is to try to preserve your rights when you go to trial, or when you go and get involved in the court, or you go before the judge or the DA and you don't have all these things working against you. Yes, the police may still arrest you if you assert your right to remain silent. Then that's going to turn on whether they have probable cause to arrest you. And if they don't, then and they still arrest you, then that can be a problem. But it's just really important that you just be careful about talking to any kind of law enforcement officer, because they are able to lie to you with no problem. They can promise you things that they can't deliver on. And I've seen many, many cases where um, people have just sold their own self down the river, and they've sold everybody else down the river too. And it's just not even necessary. You have no obligation to tell on yourself, and you have a constitutional right to remain silent. So it's always a good practice to abide by the STFU rule and practice your rights to remain silent, and then try to contact an attorney if you do get arrested, if you don't get arrested. If you find yourself in a legal situation, to contact an attorney and then let the attorney handle things from there. Also, it's very advisable never to consent to a search of your person or your property or your home unless the police have a warrant. If they have a warrant, at that point, you should consent. But short of a warrant, I've seen many people consent to a search, and then that's why they end up with problems. But I've also seen people who did not consent, and the police try to search. They found something, but it gets thrown out because it's an illegal search. And so therefore you can file a motion to suppress, and then you can get a case dismissed because you never consented. Because if there are certain situations where the police can search your house, your car, your person, but there are very specific circumstances where they can do that. Like if you're actually under arrest under another warrant or something, then they have the right to search your cars as an incident to an arrest. Or if there's exigent circumstances that they can articulate, then that might give them the right to search your car, your house, or your person. But it's just really important not to consent, because once you consent, if they have probable cause or not, now you've just given them the permission to get whatever they need to use against you. And it's always best to just refuse consent and make it known, I'm not consenting to you searching in anything. Um, Number four, this fourth tip involves having what's called an estate plan. This is a big topic that comes up all the time when we see celebrities going through death or divorce, and everybody's like, "Oh, did they have a will? Oh, they didn't have a will. Oh, she, you know." And so, while people usually think that having a estate plan is only for people who have a lot of money or a lot of assets, sometimes it's really important, even if you only have like a bank account or a house or just simple assets. Now, in most states, especially like in California, there's simplified rules for how property can transfer once somebody passes away. Um, it's always advisable to at least have a will, even though a will is not the best avenue, in my opinion, to transfer property at death. There's also the revocable or irrevocable living trust that is also an option for someone who wants to try to avoid probate and have their property just pass through their beneficiaries through the trust vehicle without having to go to court, without having your personal assets put on public record. I will probably do a separate video about the various estate planning aspects, or have my fellow Diva lawyer, Diva Fox, come here at some point to talk to you all about estate planning and the various options for that. Um, but just to touch on it quickly as a tip, it's always a good idea to research up on wills and trust and determine if that is something that you might want to consider having in place. Now, if you're okay with how your state determines who's going to get your assets after you pass away, and you're okay with that, then I mean, it's not that necessary at that point. A will is going to always have to go through the courts, and then your personal information is going to become public record. Um, but if you don't have children, in your state laws about when you die without a will, how your property is going to pass, that property might end up going to someone that you don't really want to have it. Like, say you have a sibling that you are not fond of and you don't want to have inherit all of your property, you then might want to set up a will or a trust to designate somebody other than who the state is going to designate if you don't have a will or a trust. And then with the trust, it's always good to have what's called a pour over will that will catch any assets that you might have forgotten about and still direct those assets either into your trust or to the beneficiary of that trust that you want to have those items. That's a really detailed area that definitely does warrant another video on the topic, but that's just a tip that I would advise people to look into about setting up an estate plan so that they have a clear plan as to how their property is going to be distributed upon their death. Also, another rare concept that I recently learned about that might be a wonderful tool in an estate plan is called a family limited partnership, where the family is going to put assets and income into a limited partnership, and then that's going to be perpetual. If one family member dies, the other members of the family partnership will still have access to the assets and the income of the partnership. So that's high level estate planning that can get really complex, but that is another avenue for estate planning that you might want to look into and research. And number five, I see a lot of people walking around here with criminal records, with bad credit, and they don't have to. They they don't have to have these things, but I don't think a lot of people know that most criminal records can be expunged, and bad debt, if you are drowning in debt and you don't have enough income to cover all your creditors, you do have an option to file bankruptcy, whether it's Chapter 7 bankruptcy or Chapter 13 bankruptcy, and wipe the slate clean. And I see a lot of people just choose to suffer, and I don't know if it's because they don't know that these avenues are available, or if there's some other reason why they avoid seeking out these avenues to get a second chance and to do things over and wipe the slate clean. But if you do have a criminal record for the state of California, a lot of criminal cases can be expunged and wipe off your record once you've completed probation. And if for some reason you aren't eligible for your conviction to be expunged because you served a prison sentence as opposed to a jail or probation sentence, then even in that situation, after a certain period of time, you can have your prison record. You can get what's called a certificate of rehabilitation that will um, show to the state or to the public that you have been rehabilitated, and that gives you the ability to have certain rights restored. Um, and it doesn't wipe your record clean, but it does help you in, as far as advancing forward and being able to get employment and things of that nature. So it's very advisable that if you do have a criminal record, and even if you've had like a few convictions, I've had cases where I've wiped clean a number of convictions. You have to do it in a certain order. And this is pertinent to the state of California. If you're watching this video from another state, you will need to consult with your state rules and laws about that. But for California, a lot of convictions can be erased, and I often wonder why a lot of people don't um, employ that avenue once they complete probation to have their records cleared through an expungement. Then also, as far as bankruptcy, and again, this is another area that's probably going to require a whole nother video on the subject. And I will probably put together a video about the various differences between the bankruptcy chapters soon. But just briefly, I see a lot of people walking around with like a 400 credit score, and you can't really get much lower than that. So if your income is less than your expenses, that is causing you to be drowning in debt and having a negative and bad credit score. Filing bankruptcy is also something that you might want to consider. Yes, it will take a hit to your credit for 10 years, but each year after you have gotten your bankruptcy discharge, your credit improves. And it opens the door for you to start over and to start building better credit for the future. And you know, I see people trying so hard to keep running around in circles trying to improve their credit score, when sometimes filing bankruptcy might be the way to go. So those are the 5 tips that I wanted to talk about today, and hopefully everyone will look into these tips more and do some research and take the advice here under consideration and start employing some of these tips or all of these tips into their life. And please feel free to leave any questions in the comment section. Please like this video and also subscribe to our channel. As I said, hopefully soon we'll have more videos from more of our fellow Diva Lawyer associates, and they will be doing videos to come here to talk to you about a variety of things such as legal matters, dating in the legal field, our travel adventures, and all kind of other things concerning our lives. So stay tuned. Please subscribe. Please hit the notification bell so you can be alerted when we do post new videos. And I will see you soon. Thank you.